Good morning, everyone. Thank you very much for joining us today for this webinar, Beyond Sponsorship, Immigration Compliance for All UK Companies. I can see quite a few people are still joining, so let's wait a couple of minutes to give everyone the chance to join the session before we start. Please feel free to stay around and we'll begin in 2 minutes' time. Thank you. Okay, so let's go ahead and begin. Good morning to all of you, to the newly joining people. And on behalf of the Spanish Chamber of Commerce in the UK, I would like to give you a warm welcome to this morning's webinar, where we will explore all aspects related to hiring an overseas workforce. Before we proceed with the matter in question, I would like to kindly remind you that this session is being recorded so that we can share it with you later. And throughout the duration of the session, you can submit all your questions via the Q&A function that you'll find below, and they will be answered by our speakers following their presentation. To provide some context, according to the Migration Observatory of the University of Oxford, in December 2024, 19% of employees in the UK were non-UK nationals, with significant presence in sectors like administrative services, hospitality, or health and care. 142,000 foreign employees came from Spain, and 48% European workers occupied high-skilled positions. So with constant changing legal frameworks, staying up to date about migration compliance is crucial for all UK-based companies. To help us with this, we have today Marta Mendiondo, Head of Immigration at RWK Goodman, and Amy Bennett Mitchell, Senior Associate of RWK Goodman. They will guide us through the key aspects to keep into account in order to comply with the UK migration requirements at all times. RWK Goodman is a full-service law firm established in 1873 with more than 650 professionals across 36 specialist practice areas. They provide tailored, high-quality legal services to individual, businesses, and organizations of all sizes. Its areas of practice include family law, corporate and commercial, construction, property and real estate, employment and wills, trusts, and estates. Now, without further ado, I will hand over to Marta Mendiondo. Thank you.
Good morning, everyone. Buenos días a todos. Today, we're going to cover several aspects of immigration in the UK. We can't go into minute detail on all the topics covered because that would take us weeks. It's going to be a taster session covering the following points. We're just going to touch up on immigration compliance and why it's important for your firms, how to prevent illegal working, and how to conduct right-to-work checks. Sponsor duties for those who hold a sponsor license, only a summary. This is a very vast topic, so obviously it requires a lot more time, but we'll give you a taster. And finally, the permitted business activities for visitors. Many of you will be acquainted with certain activities, but it's a very grey area, so I think everyone will welcome some clarity. If we have time at the end of the session, we'll have a Q&A, and If we don't have time, we welcome follow-up questions after the session. So why is immigration compliance important? We all have to remember that despite having checklists and having guides, etc., is not a box-ticking exercise. It has to be a holistic, comprehensive approach. And it protects your reputation, but it also protects your workforce. And of course, that means that you can continue to operate. If you have compliance issues, then the fines and the repercussions are massive. So sometimes it will affect your business, and sometimes it will lead to the business ceasing its operation in the UK. You might have read about it, you might have some guidance or legal advice in the past, but the immigration rules change all the time. You have to have a very proactive approach. And when your compliance is done properly, it will create stability, not just for the business, but also for your employees. No one wants to work for a firm who is being hit with £60,000 each time there's an illegal worker, or there are raids, or can lose its license. So obviously it helps staff retention. And showing this proactive approach as well, and having a holistic approach to compliance, will reduce the risk of audits or inspections unannounced sometimes, and obviously fines, which are quite hefty. So I'm going to hand over to Amy, who will continue on prevention of illegal working.
Morning, everyone. I just want to start with extract from the guidance, the Right to Work guidance from gov.uk, that says all employers in the UK have a responsibility to prevent illegal working. Martin's touched on it, but I can't sort of stress enough how much focus the Home Office are putting on right to work checks and the prevention of illegal working at the moment. We're seeing it come up a lot with some of our clients. And I know that some of the big sort of multinational corporations are hiring compliance officers to deal with this aspect in its entirety because the consequences are so severe. And as Marta said, the guidance on right to work checks change all the time. So it last changed, it was updated in June 2025, so only 6 months ago. So it's really important to stay on top of it to prevent the potential impacts that I'll go on to in a second. And just to say, sort of give a bit of context, the Home Office and the UK government, they are obviously wanting to crack down on illegal working because they believe it encourages illegal migration, and that leads to connected issues to do with, you know, employing vulnerable people, exploitation and modern slavery, and things like national minimum wage breaches and tax evasion. So it's, yeah, as I say, it's a big, important focus for the Home Office at the moment. In terms of the potential impacts on your business, so the sort of attention-grabbing one is the civil penalty of up to £45,000 to £60,000 per worker. So that's a huge, huge amount. That increased for 2024. At that time, it was £20,000 per worker. So I think that gives you an idea of how important the Home Office are viewing this by increasing the amount of the fines. Reputational damage. So some of you may be aware that there's actually a list, a public list online that lists the companies that have been given a civil penalty for illegal working, so it can lead to reputational damage. Right to work checks are really important if you hold a sponsor license as well, or if you're applying for a sponsor license. Not doing right to work checks correctly and the Home Office becoming aware of this can lead to an increase in compliance visits, potential suspension or revocation of the license. And it is something that the Home Office will look at if you're making an application for a sponsor license. So I had one not so long ago where there were 5 employees, all their right to work checks were done correctly, but one of the 5 wasn't recorded or properly saved correctly, and the sponsor license application was refused purely on that basis. So it's really important to get it right. There are also possible criminal sanctions or prosecutions if you know or have reasonable cause to believe that somebody doesn't have the permission to work in the UK. So you can be in prison for up to 5 years, and there are unlimited fines. And then finally, if you're a repeat offender or have employed illegal workers several times, you can receive a closure notice. Next slide, please, Martha. So just touching on those civil penalties again, the 45,000 is when it's your first breach, so first breach of the illegal working laws. If you have a repeated breach within 3 years, the fine jumps up to 60,000, and this is per worker. There are some mitigating circumstances. So if you were employing someone illegally, you'd receive a referral notice, which is essentially a form where they say who they think you're employing illegally and what the reason is. And it's your opportunity to review the circumstances and check whether you think you've done the right to work checks correctly, and put in your defence and explain the situation. If it's clear that that person doesn't have the right to work, or you've made an error and you don't have a statutory excuse, then you want to look at the mitigating circumstances. So, for example, there's options to pay early, and you can reduce the amount by £5,000. If you had already reported suspicions about an illegal worker, you can also reduce by a further £5,000. Active cooperation with the Home Office is absolutely key, and showing that you've got good right to work practices in place is really important, and can also help to mitigate the level of fine. As we touched upon, right to work checks are really crucial to the Home Office at the moment, and you can see from the figures there were 2,151 between July 2024 and June 2025. I think I worked out that it's about a 53% increase from the previous year, so it's a big jump. We have seen, and the government has said, that it's improved data and intelligence sharing between the relevant authorities. So, for example, we're seeing lots of letters to our clients from the Home Office saying that they've received information from HMRC that somebody's being underpaid or somebody doesn't have the correct permission, and that's leading to further investigation. So it's definitely correct that there's more communication between the HMRC and the Home Office. Now we've sort of gone through the scaremongering, I want to talk to you a little bit about how we can avoid those risks of getting the civil penalties or the other impacts on your businesses. So the way to avoid a risk is by establishing a statutory excuse. That is a defence against the civil penalties that we've just talked about. You can only get a statutory excuse if you've carried out the right to work check correctly, so in the prescribed manner and at the correct time. And it has to be before you employ an individual. So if you've done it correctly and it transpires a worker doesn't have the correct permission to work in the UK, you will have a statutory excuse against a civil penalty. Obviously, right to work checks don't provide a defence against a criminal offence of knowingly employing someone illegally. There's no defence that can be raised there. So the message is, do the right to work checks correctly, and then you've got that statutory excuse and you've protected yourself. So thinking first, when do these checks need to take place? So it has to be before the person starts work. I would say the absolute latest would be when they turn up for their first day, but ideally it would be beforehand to show that they've got the right to work in the UK and to do the type of job that you're hiring them to do. When you do that first right to work check, I would suggest diarising if they've got time limited permission or they've got an expiry date on their visa, making sure you diarise that so you remember that you've got to do a further follow-up check before their visa expires. If you start to sponsor somebody as a skilled worker or a senior or specialist worker, then you need to carry out a right to work check when they start being sponsored by your company. A sort of side note here, there is a grace period if you're involved in a corporate transaction, there's a change of ownership of your business and a new sponsor license application is triggered. You do have a grace period of 60 days to do your own right to work checks following a 2P transfer, but that is in quite limited circumstances, in most cases, the check needs to be done before the employee starts work. I'm just going to hand back to Marta to carry on advising on how you can carry out the right to work checks correctly.
Thank you. So how do we carry out these right to work checks, and who do we do it for? So the legal obligation is to do it for employees only. However, given the stakes and the potential fines, we recommend to extend it to all workers. So it can be freelancers, it can be consultants, it can be directors, etc. At the moment, the legal obligation, as I said, is employees only, but there is there's just been a consultation on extending this to all workers. So we advise to proactively do it already, because we know that's the direction we're going towards. So in terms of agency workers, the agency itself has to check the right to work, but also yourselves as companies where these agency workers will be working. So it's a double right to work check. And again, employed contractors, not technically and not legally at the moment, but we know that this is going to happen. It's very rare that the Home Office takes a more flexible approach. What we see is that they always enhance these checks, and everything gets more strict. So it's better to be safe than sorry. There are several types of right to work checks. The manual one, it's only limited to British and Irish citizens and those with the right of abode. This is a legal term that is going to be extinct for non-British citizens. It's not granted to non-British citizens anymore. So basically, it's rare that you'll come across to people who can benefit from the manual checks that are not British or Irish citizens. These checks are done following the guidance from List A or List B. You'd be wondering what that is if you don't know already. We're going to be given links to these lists and to the guidance. We can list and quote all the documents, etc. But as I said, these lists are always changing. The rules are always changing. So it's better to always check the guidance. This is just to give you a taste there, an overview of things you might expect. But it's always better to check the guidance just before you carry it out, to give you a statutory excuse, because as Amy said, these checks have to be done in the prescribed manner all the time and go by the guidance at the time the checks were conducted. So if you carry out a manual check for a British or an Irish citizen, you have to check the original documents. This is normally going to be a passport, or a passport card for Ireland, or documents issued by the Channel Islands, or a passport endorsed with a right of abode, or with indefinite leave to remain or enter stamp, etc. So these are physical documents that you have to see in person, and you have to check that there's a likeness with the holder. This can be done in person or via a video call, but the actual document you have to see. You cannot rely on a copy or on a PDF. You have to check that the document is genuine. Obviously, you're not expected to be an expert, but there's got to be a reasonable expectation that if someone hands you a passport that is clearly tampered with, that you're not going to be accepting that at face value. So you have to educate yourself on different types of passports, British and Irish, and also the formats when they were issued, because an expired passport can be accepted, but not a cancelled one. So if a corner is cut, that renders the document invalid. However, if the passport is merely out of date, that's fine. And the passport that was issued maybe in 1990 is very different to the one you see these days. So the Home Office also has guides on documents and how to check the veracity of these documents. So those would be these manual checks. You would have to make a copy of the document that you have seen, and you would have to make a note of the date the check was carried out. It always has to be done before the employment starts. It has to be kept during the duration of the employee's relationship with you and 2 years afterwards. And the check has to be signed, or it's got to have a note that cannot be changed, cannot be modified, saying who carried out that check. Again, you also have to check that the person who's presenting you with this document is the person on the photo. Lots of people will try and appear as someone they're not. So yes, please be careful with that. So most of the checks that you will be carrying out for non-British and non-Irish citizens will be online. At the moment, the Home Office is moving from the physical documents, the vignettes, stamps, biometric residence permits, to online status. Nowadays, most people, if not all, should have an online status, and they will be able to view and prove their status and generate a share code that they will give to you, and then you will go onto the website and check the photo, the type of work they're allowed to do, and the date. All the information will be there. So you print this off and you keep it. You make sure that the details are correct, that your organization details shows on the right to work check, etc. And then you can also use an identity provider check, but again, it's only appropriate for valid documents, which are passports, British and Irish passports. And again, it doesn't provide you with a statutory excuse. You outsource this service, that's fine, that's accepted. But if the company you're relying on doesn't do it properly, then the fine comes to you, not to them. So that's not great. If a worker cannot produce the documents or a share code, you can use something called employer checking service. This is something that the Home Office, this is a service that the Home Office provides. You send them the information about the worker. They will get back to you within 5 working days, and the statutory excuse will be extended from the expiry of the worker's permission for up to 28 days. So that's for existing employees. But this means that there are occasions where an employee has applied for a visa and their application is under consideration. If they've made an application in time before their previous visa expired, that means they have 3C leave, which would extend their previous conditions. And that is what the Home Office will be able to check. And they will confirm this person has 3C leave, which will allow you to continue employing them. And again, it will be time limited. They will tell you, okay, this is valid for a number of months, and please carry out another check if the application under consideration has not been resolved by then. If you don't have a new visa by then, you have to repeat this check. At the end of it, obviously, it will be positive or negative. If it's negative, that obviously shows that you cannot continue employing that person. If it's positive, as I said, it's 6 months. But normally, if you have an application under consideration, the applicant will receive a decision before those 6 months are up. So what happens if they do not have the right to work, if this verification notice comes back negative, or they cannot give you any documents whatsoever, if there's no way forward? The first thing we would recommend is to meet with the worker and see what they have in addition or alternatively, and then discuss with an expert. If there's nothing else available, then you'll have to dismiss the worker, but then there is a risk of unfair dismissal because they might have the right to work, but they cannot prove it. So at that point, again, it's worth consulting with an employment law expert because the consequences also can be important for your company. If it's obvious that the person, or even if you suspect that the person is been working illegally, then you should consider reporting it, self-reporting it, because that is going to, or that might be the lesser of two evils, even if you receive a penalty. If the Home Office finds out that you were employing this person illegally, you will get that penalty 100%. If the worker was sponsored by you, then you have to report it via the sponsor management system if you hold the license. And I'm going to pass over to Amy now, who's going to talk to you about sponsor duties.
Thanks, Marta. I'll try and keep this bit brief because the sponsor duties are expansive, cover lots and lots of pages of guidance, but I just want to give you a taster in case you are a sponsor license holder or you're considering getting a sponsor license, what you need to think about. So the main areas, there are 5 main areas that the sponsor duties split into. First being reporting duties. So this is to the Home Office using what's called the sponsor management system, or the SMS. There's also record keeping, so maintaining accurate records in respect of the worker and the license for the company. Complying with immigration law and the relevant Home Office guidance. Obviously complying with UK laws more generally, and behaviour not conducive to the public good. So if we move to the next slide, I'm just going to give you sort of an example or taster of what these each mean. So the reporting duties are in relation to a sponsored worker, and anything to do with a sponsored worker generally has to be reported within 10 working days. If there are changes to the sponsor organisation, you have 20 working days to report this on the sponsor management system. So these are things to do with the worker's role. So for example, if they don't start their job that they're sponsored to do within 28 days of the certificate of sponsorship date, that's something that needs to be reported. The Home Office aren't expecting you to remember every single reporting duty. They're not going to spot check you on a compliance visit, but you should have a general awareness of the types of things they want to know. And I try to say to clients, if anything changes in relation to a sponsored worker's role, so duties, responsibilities, hours, salary, just have a quick look on the reporting duties list and see whether it is something that needs to be reported. This is an area that really often gets forgotten. I say gets forgotten the most when we're doing helping clients with sponsor compliance and undertaking mock audits. So it's important to stay on top of it. Record keeping. So documents can be kept in a physical file or electronically, and the Home Office want to see documents relating to the sponsored worker, their employment, salary, recruitment, right to work checks, and you also need to keep a copy, if possible, of the sponsor license application when that was first made. The list of documents that it's supposed to keep is in guidance called Appendix D, and really you're preparing for a possible compliance visit from the Home Office. When they come, they will want to see that you have these documents in relation to sponsored workers and do spot checks and check that everything is there. You don't have to, one of the things is to keep pay slips. You don't have to sort of save every single pay slip to their file, but you'll want to be able to show that you know where they are, or can show the Home Office, or you can delegate to someone in your team who knows where they are. Complying with immigration laws and guidance. So this is to do with things like not assigning a certificate of sponsorship to someone who isn't going to take the role, ensuring that a vacancy is genuine, and really, really importantly, paying the correct minimum salary. So this is another sort of hot topic with the Home Office at the moment. We talked earlier about HMRC and the Home Office being more linked up. So what we've seen is where an employer has started to pay a worker less. Obviously, HMRC will see that coming through and they tell the Home Office. And then the Home Office writes to the employer and say, why are you paying them less? This is in line with the salary that's stated on their certificate of sponsorship. And they start to do an investigation of more workers. And yeah, it leads to a big stress for the employer. So it's important to have that all in place and correct. Complying with wider UK laws, so this would be things to do with employment laws such as paying national minimum wage or working time regulations, obviously meeting VAT and tax obligations, and as we've talked about, the duty to comply with prevention of illegal working. In terms of behaviour not conducive to the public good, so the Home Office see giving a company a sponsor license as an act of trust. They have described it as a fragile gift, and they want to know that sponsors will behave in a manner that is in line with their values and not detrimental to the wider public good. So the examples that are in the guidance are obviously not being discriminatory, acts of terrorism, things like that, all fairly obvious. But yeah, it's there in the guidance, so must be complied with. I think now we're going to move on to permitted business activities. I've seen there's a couple of good questions coming in the chat in relation to that. So yeah, we'll carry on with that.
Okay, so what happens when an international company or a company with an international operation doesn't have a license? Well, this is where the permitted business activities as a visitor is your best friend. So there are some considerations here, and the range of the permitted activities has increased exponentially since Brexit. It was a very short list in the past, but ever since 2021, we've seen it revised and expanded. This is actually really useful for companies who don't want to employ overseas workers or sponsor overseas workers, I should say, and pay the very high fees for sponsorship. This means that it's one of the few areas where the Home Office has been more generous than they normally tend to be. They're normally very strict. This is a very wide grey area, so there are a lot of things to talk about here. I'll go back to my earlier comments about always checking the latest guidance and rules, because what I may say now might change by the time you want to bring someone from abroad to be a visitor and do some work for, not work, but do a permitted business activity. There's a clear difference between the two terms, but the actual difference is, as I said, a bit of a grey area. So e-gates, as you know, to streamline transit for non-visa nationals. So the fact that you're not talking to an immigration officer anymore doesn't mean that you're not bound by the same rules as any visitor that has to apply for a visa, and the same rules apply to everyone regardless of nationality. Border records are improving, and they have more information to identify misuse and abuse. So if someone is visiting here very, very frequently, then this is going to be flagged. If someone is staying for long periods, this is going to be flagged. In the past, the Home Office or the UK didn't have an exit check, but now they are cross-referencing information with airlines, and the API that we give, the advanced passenger information, is sent back to the Home Office, which means that they have a lot of records. Sometimes they even have records when we don't travel, but the fact that we have booked a flight and given our passport information, it stays there. So You will also know that it's now mandatory to have an electronic travel authorization, and it's going to be strictly enforced from February 2026. So this is very important for those who don't have a visa or don't have a pre-settled or settled status, or obviously are not British or Irish citizens. Everyone needs an electronic travel authorization. But also, we are here in the context of the Spanish Chamber of Commerce, so many of you would be Spanish or have a Spanish connection. EEA nationals, including Spanish and Swiss citizens, are seen as low-risk travelers amongst other nationalities, but mainly European citizens are maybe subject to less scrutiny. But as I said, the rules are the same to everyone. One of the main changes from the guidance is that remote work is now permitted during visits, as long as it's not the primary purpose of the trip. In the past, it was strictly forbidden, which is, again, a bit difficult to enforce these days. If everyone has a phone, what's preventing you from checking your emails, etc.? And again, as I said, because the rules and the guidance change so much, I would always be ready to respond to questions in case you refer to an immigration officer, paraphrasing the rules if necessary. So you have to be acquainted with what the rules say. I'm going to go over that in a moment. And I apologize for the extensive nature of the next slides, because there are a lot of permitted activities. I'm not going to comment on tourism. We know what that is. For volunteering, it has to be only with a registered charity. It cannot just be any volunteering. General business activities. This is a wide-ranging area. It covers going to meetings, conferences, seminars, attending interviews, give talks, non-commercial talks, nothing involving sales, or it's as I said, there's a difference between what they would consider work and a permitted business activity. So if you are selling, then that is work. But if you are just giving a talk or are in a non-commercial event, then that's fine. You can gather information for your own employment, or you can brief your colleagues, or you can brief on the requirements for a UK customer, but it cannot be work. Again, intercorporate activities, this is, again, a bit of a gray area, because you can advise, you can consult, you can troubleshoot, you can train colleagues in the same corporate, who are part of the same corporate group. So say you come from a branch in Spain, or and you come in to give some training to your colleagues within the same group, that's fine. But if you have any client-facing activity, it has to be incidental, it has to be minimal, and it has to be to clients of the UK branch. They cannot be clients of your Spanish branch, for instance, or your overseas branch. So the devil is in the detail. You have to check very carefully. Another important one is the manufacture and supply of goods to the UK. So that would be install, repair, dismantle, service machinery, software, hardware. There's a lot of areas there, and it's not just what you see in the rules in appendix permitted activities, but the guidance, the caseworker guidance, that is an internal document that is public, but is for internal use by the caseworkers and by the immigration officers, checking whether that activity is permitted. So it's always worth checking both sources of information, because there's going to be more detail in the guidance than in the rules, but the rules trump the guidance. So if there is a dispute between the two, which often happens, you always have to go by what the rules say. For clients of UK export companies, you can be seconded to oversee the requirements of this clients, but of to oversee the requirements for goods and services, but you cannot be part of the same group. Again, it's an export company, so the visitor as the client will be coming to the UK to check that what they are getting is what they need. Again, overseas roles requiring specific activities in the UK. This is wide-ranging. Again, it can be translators, interpreters, bodyguards. It can be a tour courier or leader. It can be a journalist. It can be a professor with overseas students who can actually give a reduced amount of teaching, which is, again, one would think that is working, and it's not specific how much teaching they can do. So that's why I say this is a grey area. And if possible, I would err on the side of caution. But there's a lot of overseas roles like drivers as well. Some seafarers in ferry services, not workers working within 12 nautical miles. So dredgers cannot be a visitor. They need to be sponsored, but someone working for a cruise can come and carry out their duties if they are coming into a port and leaving or delivering goods or services or people. It's not listed here. I think the slide was too small to include this, but also work-related training should show there, and this is for medical and dental and nursing training, and for graduates coming for a clinical attachment or to oversee posts. It's not generic to other types of trainings, which is covered in other areas. Science and academia, again, academic scientists, researchers can take part in informal researchers, or they can give talks, etc. They can collaborate. There's a wide-ranging amount of topics here, so I'm not going to cover it all. Legal professionals, they can come to be expert witness or to give evidence, witness to give evidence. Religion for pastoral work or for preach. Creative workers, normally artists, they can come to give performances. They can appear in festivals as long as they are part of the permit-free festivals. There's a list, again, published by the Home Office on what festivals they can attend. And they can be the team members of these artists who are, setting up the scene for their performance, as long as they attend the same event. And this also includes film crews. If there's a production which is being shot in the UK but is being produced abroad, they can also come and do these permitted activities. Medical treatment and organ donation is self-explanatory, and study as a visitor, which does not include long-term studies. This is, again, very specific to courses of study of up to 6 months. It cannot be for 6 months consecutively. If the course lasts longer, it cannot be done in repetition in lieu of or instead of a student visa. And there are some useful links there that are going to be circulated by Miriam at the end of the presentation, just to give you an idea. As I said, the first one covers the permitted activities, and it's worth checking the guidance as well, which is the second link. That's the caseworker guidance, to give them a bit more context, and it's a document that changes on a regular basis. And the last two links relate to the guidance for sponsors, what Amy has discussed about compliance duties. And the last link is about right to work checks, which I covered earlier. So that is the end of our presentation, and we appreciate it's a lot of information, and you probably have questions. I'm going to hand over to Miriam now, who will handle the questions for us. Thank you.
Thank you very much. Thank you very much, Marta and Amy, for sharing your expert knowledge. We will now open the floor to questions. So I'll have a look at the Q&A function. You've been sending through some questions already, but also feel free to keep sending questions now through either through the Q&A function, either raise your hand if you want to participate in person. You can turn on your camera and your microphone, and we'll be happy to help you with that. Marta, Amy, let's start with knowing how you can assess our attendees, our participants, related to all these you've just explained.
Do you want to go, Marta, or do you want me to take it?
Go ahead, please.
Okay. So we help lots of companies with training. So we can offer training on right to work or sponsor compliance. And we also conduct mock audits or compliance visits and pretend that we're the Home Office, essentially coming to have a look at your sponsor license and doing spot checks on employee files and talking to your employees to check that they're doing the work that they're sponsored to do. We also have lots of clients where we just offer ad hoc support. So if you have questions that pop up in relation to permitted business activities or right to work checks or anything to do with immigration, you're very welcome to get in touch with us. We can set you up as clients and just answer, provide advice as and when you need it. There's lots, as you can probably gather, there's lots and lots of guidance, and it changes constantly, but we are here to assist as needed. So yes, do get in touch.
Thank you, Amy. I don't know if Marta wants to add something else, or shall we go straight to the questions, to the rest of questions?
No, I think we can go straight to the questions.
Perfect. I'd like to know if there are any specific sectors that are specially targeted by the Home Office.
Amy, do you want to go?
Sorry, I was reading the chat. You go for it, Marta.
Oh, sorry. I'll answer then. Yeah, well, we are seeing a massive increase in healthcare, in the healthcare sector. The requirements were loosened for this sector. It was also cheaper to sponsor, and there was a massive gap in the market. So sponsorship grew exponentially from 2021, but with growth comes abuse as well. Some rogue employers have been abusing this area, and others through non-compliance, because it was unbeknown to them that they had to continue reporting and continue paying as they said they would. And the healthcare sector has got important challenges for the type of work they do. It's not always a specific amount of hours, etc. So there's a lot of reporting, there's a lot of compliance checks, there's a lot of license revocations, and this leads to visas being revoked as well. So not only the company is hurting, but the actual worker whose visa has been cancelled has to find a new sponsor, and that's not easy.
Okay. Yeah, I think
there's other sectors like IT as well, but mainly I'd say if we were to go for one, is healthcare.
Okay, thank you. We have a couple of questions quite related. So I'll start with the simpler one. What happens if the employee did have the right to work at the time of being hired, but then at the time of the checking, they no longer have it, or they are in the process of renewing their visa, and so there's this point where they might not properly have the right to work. This is the first one, and related to this, if someone's right to work ends, if the final salary run is after their final date of for the right to work, can an employer still pay them for work done when they legally had the right to work? And what about accrued unusual annual leave?
The answer is yes. You should pay them for the work that they've done whilst they still had the right to work. and for any accrued but untaken holiday from when they had the right to work. Otherwise, there's potential employment issues or unlawful deductions from wages issues there. So yes, to pay them.
Okay. And I reckon if you are as an employee, you are in the process of renewing your visa, and you can prove that. As an employer, as an employer, you can also fact check that towards the Home Office.
Yeah, so that's what Martha talked about earlier. It's called Section 3C leave. So as long as you've put in your new visa application before your existing visa expires and the application is valid, whilst the Home Office is making a decision on the application, you're protected. You still have a right to live and work in the UK, and your employer would need to use the employer's checking service. And the Home Office will be able to confirm that there's an outstanding application or a pending application. You could also, just to be safe, ask the employee to give you proof that they submitted the application. So just the front sheet of their application form or confirmation of payment or something of that nature.
Okay, understood. Well, we have a specific case here that I think it can be really, really helpful from what you've already mentioned. We have a Spanish employed individual, employer by our group, who visits the UK less than 60 days a year to interact with clients, attend meetings, inspect sites, and interact with employees. The client gets billed by us and for whether the person is on site or abroad. Previously, we paid for a visa for him, marking he was being paid by Spain, but to cover any work beyond meetings and also for showing where the person is based. He, however, is not a UK employee and remains on Spain payroll and is less than 60 days a year. So is paying for sponsorship overkill?
Shall I take that one? Amy?
Yeah, sure.
Yeah. Okay. Well, I wouldn't say it's overkill. I know it's a massive expense, but there is an element of client facing in those visits. If he was only attending meetings, internal meetings, and yes, inspecting sites, and again, that can be framed within the permitted activities, then yes, fine, he can come as a visitor. However, I think what you're describing is a varied role, and there's a big risk that he's actually working in the UK. It doesn't matter if it's for a long or short period. I understand he's being paid in Spain because he's not tax resident in the UK. He's in Spanish payroll, etc. I have clients in this predicament, and their activities are classed as work, and they're coming to the UK for projects of maybe 5 days or less a year, and they still have to sponsor them. What you can do is you can go for a shorter sponsorship period, but again, in the long run, the admin cost and having to renew visas is probably a bigger expense altogether than the actual monetary cost of applying for a long-term visa. This person is never going to settle in the UK because they're not meeting the minimum residency requirements. It's a low-risk person, and there might be quite a few things that they're doing that can be a permitted activity, but I don't think his sponsorship is overkill, because it seems to be quite related to activities with the client. But we would need more details to give you a specific answer. It's very difficult to have an overview on the spot with limited information.
Thank you. Another specific case. We have an employee on a senior specialist worker route for 24 months on a project. Her dad wanted to stay with her while she's in the UK, but he cannot be sponsored in the same way as a partner or a child. We talked to our lawyer, and he said sponsoring a parent is very complex, as you have to provide that he needs care and cannot get in Spain. Our lawyer also said the best thing is longer visits with returns to Spain, but they ask if there is any way we can lobby the government so that workers who are willing to relocate to the UK with elderly parents are not penalized or held back, as parental caring is not considered in the same at the same level or in the same importance as a childcare or bringing a partner, for example.
Will I take that one?
I think I'll take this one because this is very close to the sort of inquiries we get all the time. Right. Lobbying, that's never going to happen. The Home Office is very clear on the intention of just bringing high-value migrants, someone who is elderly, not an active member of the company, sponsored workers, someone who's not paying into the system, is never going to be a priority. In fact, we're coming from a relatively generous regime, and the Home Office took a conscious decision in 2012 to basically not allow any elderly dependent. It's the most complex application that there can be, and it's never going to work for any European applicants, because the first thing you have to prove is that you don't have the medical care that you need in your country of origin, or that is not affordable. In Europe, we have, in Spain, we have Seguridad Social, and in Europe there are similar arrangements where, you know, there's normally a healthcare system. So where there's a healthcare system, that's never going to work. It's the premise of the law, and that is the direction the government is going towards. What would happen to this elderly person? The UK is very restrictive in sponsorship, but it's actually really generous for visitors. It's more generous than the EU. A visitor can stay up to 6 months at a time, and there's no cooling off period. So this person can visit on multiple occasions, of course, abusing the system by basically living here for long and successive visits. It may happen for a while, but it will eventually get spotted. So you shouldn't abuse, but on the other hand, conversely, there's not a specific amount of days you need to stay out of the UK to be able to come back in, as long as you satisfy the criteria of being a genuine visitor every time you come in.
Okay. Very interesting. Thank you. Let's jump to another question. With regards to online right to work checks, what is the best way to check a foreign passport? And does the check need to be done in person again upon worker arrival in the country?
So if the person has an e-visa, then you'd be doing an online right to work check using the share code, and there's no requirement to then see the original documents. So there would be, no need to be done in person again upon arrival.
Okay, thank you. Is a permitted business activity traveling to the UK every 2-3 weeks to oversee a UK limited company for a self-employed in Spain? Is it permitted? Is this permitted?
When you are gathering training for your own employment overseas, that is not available in your country of origin. So if this self-employed person doesn't have a direct employee relationship with that company or with any company of that group, you could class that as training that is not available in your country of origin, and that is a permitted activity. But again, the devil's in the detail. Always check before you intend to do this, and be prepared to be questioned. And when you are questioned, then know where the source of information is and paraphrase it. Don't give your own interpretation of the rules. Say, if you coming, what I would recommend is that people know by heart what they're coming to do from the rules, and this is actually quoted in the appendix, permitted activities. Coming for training that is not available in your home country for your own work abroad. And then the other thing I would recommend is, if you have overseas employees coming to visit your UK branch, to come with a letter from the overseas company and from the UK branch confirming what they're coming to do, this is, if you're going through e-gates, it's unlikely that you're ever going to be questioned. But if you have something in writing that paraphrases the rules, and it's you making life easier for yourself and for the immigration officer, who might not actually know that part of the rules. We're all fallible. It can be, that person can have a bad day. It's good to quote from the actual rules.
Okay, but only if you come for training purposes. For example, if you are the owner of a Spanish company who has a branch here in the UK, which has a branch here in the UK, and you are the owner, the managing director, the CEO, and you are coming to oversee how everything goes here, you should have a right to work, and I mean, you should be sponsored.
Well, it's not called right to work. It's right to work is for those who are employees, and you do before employment in the UK. You would be permitted to carry out this activity as a visitor. It's a different concept, and again, the key, they call it permitted activity because they don't want to call it work. So you don't have a right to work.
Okay, understood. If we employ a non-sponsored worker through our EU registered entity rather than our UK registered company, and they comply with one of the permitted activities, can they still live in the UK, or does their main address need to be outside of the UK?
Well, they wouldn't
the main consideration
have the right
for a visitor.
Yeah, go on.
Yeah, the main consideration for a visitor is that the visit is no longer than 6 months, and that they are going to leave the UK at the end of their visit and not make the UK their main home through frequent and successive visits. And this is where I said there's no cooling off period, but if you abuse the system, it's clearly against the spirit of the rules. So the short answer is no, they can't live in the UK. And again, they can carry out a permitted activity, they cannot work.
Okay, perfect. And last question, is there a timeline for the right to work check for freelancers?
When the government announces it.
Yeah.
Again, when rules change, they give us a very short notice, normally around 21 days, but sometimes it's longer, sometimes it's shorter if they want to implement something right away, because it's secondary legislation. They can do so without much notice, really. So the way to change rules it can be very, very fast, but normally they'll give us a 3-week notice, and the consultation has just finished, so we don't know when that's going to happen.
Mm-hmm.
But okay. They're still analysing
we expect
feedback.
Lots of changes. Yeah, we expect lots of changes to occur in 2026, as you know, and I would encourage everyone listening to this to complete the. There's a consultation. I would encourage everyone to complete it, because you don't have to be a lawyer, you don't have to be a worker. This is going to affect all companies. This is going to affect society as a whole, not just migrants. So if you go onto the consultation and give your honest answers, whichever your views may be, that will be welcome, and that should give the government information as to whether what they're proposing to do is fair or unfair.
Okay.
I have a very clear opinion on it.
We just wanted to wrap up with this question. What compliance changes or enforcement trends do you anticipate in the next 12 to 24 months? I don't know if you can give a hint of anything happening.
I think they're going to carry on as they are. I mean, the HMRC link-ups with the Home Office are very recent. We've only seen those since probably October last year, and now they're coming through pretty regularly. So I think they will continue and become more frequent. The Home Office have a lot on their plate, as Marta has just alluded to, with changing the settlement rules. So I expect the focus is going to be disseminating, implementing and understanding those new rules for 2026. So it will just be more of the same with compliance and quota checks, really.
Okay, thank you.
I think there's also another trend which we can see in the EU settlement scheme on nationality applications as well, and it's going to trickle down all the departments in the Home Office, and is the cross-checking border force records. And as I said before, they're not 100% accurate. So if it doesn't match what the requirements are, then they'll give you an opportunity to address those concerns. Because if, as I said, if you have booked a flight but haven't taken it, or if you come to the UK via Ireland and there's no border check between Ireland and the UK, then there's not going to be a registry of your entry into the UK. So you can address those issues, but we are seeing a more proactive approach from the Home Office saying, actually, we don't believe you meet this criteria, this residential criteria, etc. So yeah, we see that a lot, and that also affects visas which are curtailed after sponsorship finishes and the Home Office takes action and cancels someone's visa. If their records show that that person is outside of the UK, they will cancel the visa immediately. Whereas if the person is in the UK, they will give them a 60-day period from that point to find a new sponsor or a new type of visa to apply for.
Interesting. Very interesting. Thank you very much. We are now bringing our event to a close. Thank you once again to our speakers today, to Marta and Amy. And thank you all for attending. I hope you found it both interesting and useful. Later today, you'll receive an email with the recording of this session and the links Marta just mentioned with useful information to deep dive about the topic in question. If you have further questions, please don't hesitate to reach them directly. You'll also receive their contact emails, their contact details. They will be more than happy to help you. And from our side, I'd just like to remind you that we are hosting 2 events in Manchester next week, next Thursday, 29th January. The first one will be a Melia Business Breakfast with Ferran Soriano, the CEO of Manchester City. It will be followed by a business briefing given by the Greater Manchester Combined Authority about business opportunities in the city region for the upcoming years. You can find more information and sign up on our website. Thank you very much. We look forward to welcoming you again soon. Have a nice day. Bye.
Bye.